um, one of one of our guests, who is a friend of Jessup, a friend of mine. His name is Miko Solis. He's a law professor of civil law and constitutional law at St. Paul School of Professional Studies. And he's also an experienced mooter and experienced moot judge. He's mooted at the IBA ICC moot court competition, and he's been a judge in the International Indonesia um, moot court competition of 2024 and 2025. And today he's here to lead us on a discussion on state responsibility in international law. So, Miko, thank you so much for joining us today. I appreciate it. And I hope everyone will learn a lot from you today. So the floor is yours.
Thank you, Lauren. Good evening, everyone. I apologize for the noise because it's currently storming in our country. So we are in a we're in the middle of a typhoon. So if you hear some unnecessary noise, I apologize in advance. So let's start with state responsibility. All right. So when the state breaks international law, it doesn't get immunity just because it says that we're a state. You cannot sue us. International law says when you break international law, you fix it. It means you stop the act of breaching an international law obligation. You repair the damage or make sure that such violation does not happen again. So let's define what a wrongful act means for basics. A wrongful act could mean a breach of international obligation. And number two, it could be a conduct that is attributable to that state. If you remember the Corfu Channel case decided by the International Court of Justice in 1949, the UK versus Albania. This is a famous case for international law students. Albania did not plant the mines, but Albania knew that the mines were there. But what was the fault of Albania? Albania failed to warn the ships passing there. So the court said that Albania had an obligation to not let the territory be used to harm in ways that would harm others. So that is an example of state responsibility. Now, where do we get the source of state responsibility laws? We have the RCWA, ARSIWA, which means Articles on Responsibility of States for Internationally Wrongful Acts. So RCWA has already attained customary international law. So how did that happen? Well, first, the ILC, adopted by the UN General Assembly in 2001, drafted the RCWA. And eventually, RCWA has attained customary international law status. How did it happen? So if you can still remember, what are the requisites in order for a law to attain CIL or customary international law status? There are two, and this is basic for mooters, this is basic for international law students, state practice, and opinio juris. So it becomes a state practice when, number one, the ILC finalized RCO in 2001, and gradually several countries began using it in their diplomatic affairs with other countries. And excuse me, when they argue before international courts, they have often invoked the rules on RCWA. Now, what about opinio juris? It is not enough that the states should behave in line with the rules in RCWA. They must they must do. I believe there's a they must they must do so out of a sense of legal obligation and not mere convenience. So when the state would cite rules on the RCWA as a law, that's their utilization of the concept of opinio juris. But of course, there are also international courts who have cited RCWA as well. And remember that the ICJ has already cited RCWA in some of its restatement regarding state responsibility. Of course, the UN General Assembly has also used rules on RCWA since 2001. So if you're asking me if RCWA has attained customary international law status, it has already attained such status. If you can remember the Bosnian genocide case in 2007, the ICJ relied on RCWA principles, even though it's not a treaty.
International something. This is impressed.
Okay? Well, thank you for muting your microphone. All right. So to boil down the basics of RCWA, if you breach an obligation and the act is attributable to your country, state responsibility comes in. And what is the law that should be applied? RCWA. So I believe in the next few weeks, October 19, October 20, our team in my university where I teach, we will be joining a moot court as well that deals on environmental law. And this RCWA is one of the sources of the laws that we will be using in our memorial and in our oral rounds. So, as well as in Jessup and other moot court competitions, issues or cases or moot problems that deal with state responsibility, then our SIWA is the source of law that should go with. Think of state responsibility as tort law for your states. Do you remember your law on torts in your law school? So, if you cause damage to another person, perhaps, you by negligence or by recklessness, you pay damages, right? The same is true with respect to RCWA. If the country is negligent, like in the UK versus Albania case, the country was negligent in not informing the passing ships that there are mines on that body of water, then that state has legal obligation. And we're not talking about international criminal law. We're not talking about imprisonment. We're not talking about punishment or criminal liability. We're talking about the reparations or payment of damages. One of the things that you'd also learn about RCWA is the element of state responsibility. What we have here is number one, attribution. What does it mean? We have used this word attribution in our memorials as well for our future competition for the environmental law moot court. Attribution means the conduct must be attributable to the state. So it doesn't mean that only governments or only organs of the state or only officials of the state. It can also cover private individuals if that private individual is under the state direction or control. But generally, state responsibility, when we talk about attribution, it covers actions acted or done by the states, by its officials, or even if it was done by a private individual, as long as that private individual was under state direction or control, then the attribution element kicks in. Let's try one case. The classic case of Nicaragua versus US. In this case, the court introduced the effective control test. Because you see, what happened was the United States of America was responsible for the acts of the Contras. Because the Contras had, US had control over the Contras for day-to-day control over their operations. So when US said that we were simply funding or training them, it was not enough. For example, if you give someone a gun, that doesn't make you responsible for every shot they fire. Effective control means you're the ones calling the shots. You're the ones commanding those persons, handling the gun when to fire such gun. Such analogy exists in the case of Nicaragua. So in that case, the effective control test, US was responsible for the acts of the Contras because the US had control over the operations of the Contras. Hence, the acts of the Contras was attributed to the United States of America. Number two element is the breach of international obligation. Once you have completed the element of attribution, you now go to step two. You ask yourself, did the conduct of the state violate an international obligation? If yes, then the state has breached international law. Let me give an example. The breaches can include violating another state's sovereignty, like what's happening in our country. China is violating our right to our exclusive economic zone. But recently, in 2016, actually, the Permanent Court of Arbitration has held that the West Philippine Sea is ours. The West Philippine Sea is Philippine exclusive economic zone. Hence, the sovereign rights over that body of water belongs to us, the Philippines, and not to China. But nevertheless, China has continuously violated that international decision by the Permanent Court of Arbitration. But nevertheless, it also violated the UNCLOS because the UNCLOS provides 200 nautical miles from the baseline is our exclusive economic zone. And that is thousands, how many miles beyond China's baseline. So when you talk about the UNCLOS, the law, conventional law of the seas, China breached that UNCLOS. So there is a breach on the part of China. Was it attributable to China? Yes, because the vessels that were violating our sovereign rights bears the flag of China and even harasses our fishermen, harasses our coast guard, and saying that you should leave because this is China territory. They openly admit that they are the Chinese vessel, that they are representing China, and they are acting on behalf of China, and that this area of the sea is theirs. So they violated our EEZ, and they openly admit that they acted in behalf of China. So the attribution part, acting on behalf of the state, is just an organ. And number two, the breach of international law. So I believe state responsibility, the requisites of state responsibility has already been complied with. Now we go to the circumstances precluding wrongfulness. What are the excuses that can be used by states? Number one, they can use consent. They can argue the other state or the offending state or the accused state can simply raise as a defense that the other country consented to their act. Number two, the all-time favorite, Article 51 of the UN Charter, self-defense. Again, we attack, Israel would again invoke the self-defense doctrine. Iran, on the other hand, would also invoke the self-defense doctrine. So they would bomb each other. Next, countermeasures, lawful reprisals short of force. These are unlawful acts taken in response to another state's wrongful conduct. Force majeure, of course, in your civil law, force majeure is defined in our jurisdiction, at least the Philippines, we define force majeure as it could include acts of God, it could also include things or events that are unforeseen, and even if foreseen, are inevitable. So that is force majeure. I believe that is a universal concept. Number five, distress. Distress arises when state officials no other reasonable way to save lives. For example, a plane violating another state's airspace, just because it needs to make an emergency landing and save passengers. Well, technically, the plane has violated the airspace of the Philippines, but nevertheless, that state requires to do such violation in order to save human lives. That is excusable. Number six, necessity. This is the most controversial one. The state may invoke necessity if it's the only way to safeguard an essential interest against grave and imminent peril or danger. But we have a case in the ICJ on during 1997, the Gabčíkovo Negimaros project, wherein Hungary, the country Hungary, tried to argue necessity to stop building a dam, claiming the environmental danger. Well, the ICJ said, okay, nice try, but no. Necessity cannot be used if the state has contributed to the situation that it prevents. So in that case, the ICJ did not accept the necessity as an excuse. So to wrap it up, these circumstances or these enumeration, the consent, self-defense, countermeasures, force majeure, distress, and necessity, um, while it is true that they would admit that they have committed that act, that they have committed a breach of international law, they would raise as a defense that the state only did such breach because of consent, self-defense, countermeasure, force majeure, distress, and necessity. Excuses, for sure, so to speak. Now, what are the consequences of state responsibility? If the state responsibility elements are proven, the consequences are number one, the cessation and non-repetition. Well, of course, the state that acted on the breach must cease such breach or must stop from doing the wrongful act immediately. And of course, if you're still occupying someone else's territory, you have to pack your bags and go. There's also a concept of non-repetition. If you stop doing the breach of international law, it should follow that you promise not to do it again. That is cessation and non-repetition. Next, reparation. This means that the state has to pay for the damages, whether to another state or to an individual. The case of Chorzo factory case by the PCIJ in 1928, and I quote, it said, reparation must, as far as possible, wipe out all the consequences of the illegal act. Unquote. Reparation and is done. Restitution, compensation, satisfaction. When restitution cannot cover the breach of international law, compensation will step in. It means you will pay the money to cover the damages caused by the wrongful act. If you bomb the city, you can't just pay restitutions. You have to compensate for the damage that you have done. It's not just merely taking back. It's paying for the damage that you have done. And then next is satisfaction. Satisfaction is more symbolic. Apologies, recognition of wrongdoing, or even memorials. I believe the famous case is the the Holocaust. So the Holocaust, we can always see uh, laws in Germany wherein you are penalized if you act a certain way that the Nazis did before. So if you do the Hitler salute or you talk about anti-Semitic rhetoric or simply by mentioning the name of the famous German dictator, I believe is penalizable in Germany. So we went to Berlin last year, and there is a Holocaust memorial. There are graves of the murdered Jews of Europe. So that is symbolic. That reminds the people, that reminds the world about the atrocities that have happened before. We go to serious breaches. Now, this is something else. Serious breaches and erga omnes obligations. There are certain obligations that are owed to the international community as a whole, and we call it erga omnes. And this is very famous nowadays: genocide, slavery, aggression, and torture. Now, not all wrongful acts are viewed as equal. Some violations are so grave that they do not that they're not just against one state, but the entire international community as a whole. So the genocide in Palestine is not just against the state; it affects the whole community as a whole. That's why we call it erga omnes obligation. You might say, what is erga omnes? That's not English. It's Latin. It means towards all. These are obligations that the states owes to the international community, and every state has a legal interest in their protection. And you can observe this in the situation in Palestine. So South Africa filed in the ICJ, even if they're not anywhere near Palestine, but because this is an erga omnes obligation, other states can file a case in the ICJ because genocide is one of the coverage of erga omnes obligation. The prohibition of genocide, the prohibition of slavery, the prohibition of aggression, the prohibition of torture. In your international law, this is very basic. The jus cogens, Juscogens. You remember that is called the peremptory norms under your VCLT, the Vienna Convention, the law of treaties. If you've undergone international law subject during your undergrad or law school, your international law professor would tell you that the jus cogens or the peremptory norms is on the top of the hierarchy of international law. No derogation is allowed. So that is where erga omnes obligation sets in. It is because genocide is a violation of a jus cogens or a peremptory norm that it becomes an erga omnes obligations, that it covers the entire international community. And even if only one country or only one state has been inflicted by genocide, the international community will treat such violation, for example, genocide, it will treat the crime of genocide as a crime against all of humanity. Which is why in the ICC, under Article 7 of the Rome Statute, we call it crimes against humanity. Now, how about the enforcement? Well, actually, that is where this whole thing about the situation in Palestine is goes wrong. The enforcement. Now, we've already issued warrants of arrest against Netanyahu and Yoav Galant, but the ICC cannot in any way force Mongolia and other states parties to arrest Netanyahu. Netanyahu was even applauded in the U.S. Congress, despite the fact that there is a search or there is a warrant for his arrest. Now that is a challenge. While it is true that we have international law, the difference really lies in enforcement. Now in the Philippines, in our case, you're familiar with our former president, Rodrigo Duterte. He is currently detained at The Hague, Netherlands, in the ICC detention facility. Now, the crimes charged against him were also under crimes against humanity because of his policy of war on drugs. So, just to give you a story or background of that case, during his um, tenure as mayor in Davao City, a small city in the Philippines, he implemented this war on drugs wherein he would kill suspected drug pushers. Fast forward 2016, he won as president of the whole country. So us Filipinos were under his jurisdiction as president. Now he implemented that war on drugs policy, the killing of suspected drug users and drug addicts. implemented that to the whole archipelago of the Philippines. And then ICC went in, conducted preliminary examination. Witnesses were interviewed, evidence were gathered, and ultimately he was arrested last year. He was detained last year at the Hague ICC detention facility. But what about the other accused? What about other violators of international law? How, like in the case of Benjamin Netanyahu, the enforcement is really where international law is weak, which is why in that slide I indicated weak enforcement. Now, to close my lecture, to close my session, serious breaches in erga omnes obligations remind us that international law isn't just about bilateral disputes. It's about protecting the core values of international community. So in other words, when the stakes are humanity itself, everyone gets a seat at the table, not just the state. We're not just talking about state responsibility. We're talking about the entire international community as a whole. Free Palestine. Thank you. Fortunately I have to go now, Laureen. Um, uh, because my team is waiting for me as well. If you have any questions, you can just I will give you my contact and Laureen will give it to you. Thank you, everyone. Have a good day.
Okay, thank you so much, Rico. Have a good day too. So if you have any questions, direct them to me and we'll direct it to Nico to respond to you. Or yeah, I will give you his contact and you'll be able to contact him and ask any questions you have, and he'll be able to respond to them in the process. So yeah, thank you once again, Nico. Hopefully I'll see you soon. So we have 8 minutes till the next session. So the next facilitator is yet to join the meeting. But that is okay. That is okay. So we'll wait for her to join the meeting. So as we proceed, might anyone have any questions when it comes to administration? So specifically on the administration of the competition. I saw some questions in the comment section while people were registering for the event, and they're asking how administration is really conducted for the competition. So I can explain briefly, but sadly my point of view will heavily be the Kenyan administration process, which is generally almost the same since we use a similar backdrop of rules to administer the competition. So yeah, after the preparations and all, if a country has 2 or more teams, they have to conduct qualifying rounds, which others refer to as national rounds of the competition, to determine who will be representing the country in the international rounds of the competition. So usually, out of every 8 teams, 1 team will proceed. So if a country has 7 teams, only 1 team will proceed to the international rounds. If the country has 9 teams, 1 team will proceed. But if it has 16 teams, 2 teams will proceed to the international rounds, and so on and so forth. Yeah. So the administration is quite simple. Usually the rules are as per the 2026 Jessup rules. You'll have the preliminary rounds where necessary. You'll have the quarterfinals, then the semis, and then the final rounds determining the national champions. So usually they're referred to as the national champions on every social media. And yeah, to be able to access the contacts of your national administrator, it's usually on the Jessup website. So I will direct you on the same tomorrow. I will show you step by step how to access various details on the Jessup website so that we ensure that every single person knows where to find anything on their website. Yeah. So yeah, you can be able to access the contacts of your administrator. For example, my contact as Lorena Tieno, you'll find it under the Kenya Jessup rounds. And you'll also find the details of the venue and the dates of the competition on the same website. Yeah, might anyone have any questions when it comes to national administration? Any question?
Me?
Yes, Marcos?
Okay. First of all, I want to introduce myself.
Mhm.
First of all, I want to introduce myself. My name is Sermias, and I want to say thanks for you have give this opportunity to me. Now, uh, what is my role in this meeting? First,
Yes? Pardon?
what's my role?
I kindly come up again.
Okay, what is my role? The role
What
that I
is
play in meeting.
in the competition,
Yeah.
or what is your role? So it depends with how you register for the competition. Yeah. So as I'm assuming you're planning to register as part of the team. So when you register for what you'll be doing is preparing for the memorial rounds of the competition, which will be due on 12th of January 2026. And then afterwards, you'll be participating in the national rounds. So if you're a team of two, both of you will be participating in the oral rounds of the competition, since only two oralists are needed to present at every round. But if you're more, you can either have two designated persons presenting, or depending with the comfort of the team, that is not for us to dictate. Um, you will you can decide that maybe a group of two presents for the applicant side, and the other two prepare for the respondent side. You can participate in a team solely as a researcher. If that is your strength, you won't be stopped from doing that. Yeah. However, especially in the international rounds, if you want to be awarded as one of the best oralists of the competition, you need to have mooted once as a respondent and once as an applicant. Yeah, once as a respondent and once as an applicant. So if you only moot as an applicant, you won't qualify for the grading of the best oralists in the competition. So that is just an FYI. And yeah, so generally that's it. That your role is to prepare, research, and present both the written rounds and the oral rounds of the competition.
Thank you.
Okay, welcome.
Now, it's a good chance for me. I will try to join as a respondent.
Okay,
No,
okay. You're from which country?
I am from Ethiopia.
You're from Ethiopia. Okay. So
Yeah.
I look forward to seeing you joining. Okay. Any other question as per administration of the competition?
Yeah. The second question is what topic is given to us as a
What
title
topic?
or the issues that makes to compete each other?
Okay. So um the topics of the competition are usually outlined. Actually, they're usually released in May or June every year, the year preceding the competition. So if you've reviewed it, as part of my presentation tomorrow, we'll be able to discuss about what are the general principles of international law. There's a question relating to indigenous persons. There's a question relating to whether how another party can, whether another party not really whether how another party can join a case, yeah, and many other questions. There are specific questions, but they've been outlined in the website, and also the question is already out. Yeah, so if you need more details on the question, just check the Jessup 2026 website. It will give you more details on the same.
Okay. The title is already given to me in my website.
What?
The title is given to me.
What is given to you? Pardon?
Title or issue?
Okay, I cannot get you clearly, but the website is ilsa.org. ilsa.org, or if you just Google ILSA, you'll be able to get information about the competition, and you click on Jessup 2026 and you'll get more details about the competition. I hope that answers your question. Does anyone have any other question on administration? Oh, I'm stalling as I wait for the next facilitator to join us. She sends her apologies and she'll be joining us soon. Yeah, okay. So I hope that is okay. Remember, you can access the contacts of your administrator on the Jessup website. So if you have any questions on how the national rounds are being administered, or generally any question you're not sure and you would not like to direct the question to file. And usually in other instances, the administrators also assist you in resource mobilization for the competition. So if you need support to the same, you can always liaise with your national administrator and they can see how they can support you in one way or another. Yeah. Okay, someone asked whether I'll share the recording. Yes, I will share the recording of the session after the meeting. Your fellow colleagues have shared that, especially due to the time differences between our countries, some of us are still in class or lectures at the moment, and they will not be able to join us. And I want to make this as accessible as possible to everyone. So I hope you agree to me recording the session. Can I share? No, I did not record yesterday's session, sadly, but I've shared a recap with everyone. I believe you've received it by now. I've noticed that there are some people who inserted their email addresses wrongly and the email is bouncing back. So if any of you have that issue on your side, you can contact me and I'll be able to add you to the thread and share with you your emails. Or anyone who might have missed the session and they might need the resources, you can also share their contacts with me. And any of the resources, the slides that is being presented and the recap I'll be sharing with everyone who is on the listed contacts. Yeah. Okay, so maybe I can briefly start on the next session as you wait for our facilitator. Yeah, and hopefully I can engage you. Oh, I can see she's in. Sally, are you ready, or you'll signal me when you're ready to start? Yeah. So maybe someone um can engage me here. Yeah. So when you hear the term compromis, yeah, what comes to your mind? What is a compromis? Yeah. Dennis mentions that it's a statement of agreed facts. Yeah, that is correct. Yeah. For a long time, the Jessup competition has worked with a compromise, so a statement of agreed facts. And as you'll note from the format of most compromises throughout the years, it will start with the agreement between the states to proceed or to bring their case before the International Court of Justice. So I haven't seen a different form of statement of facts being submitted, I mean, being used for the JSAP competition, but perhaps we'll see that in the future. So yes, the compromise is a statement of agreed facts. Another question, um, what law or what article um, gives the state the the what the duty or the obligation or the power to submit a compromise to the ICJ? Anyone? Yeah, Gotema mentions Article 36 of the ICJ statute. That is very correct. Yeah. So remember that the International Court of Justice is guided by um is guided or yeah is guided by the statute of the International Court of Justice. So even as you prepare for the competition, I believe some of you mentioned that you're new to the competition. Remember that as you research into the details or the contents of the details or the contents of what the moot question is asking you about, you're also supposed to understand what the Court of Justice does. So what the Court of Justice does, what is the authority, what gives the court the authority to listen to such questions, what gives the states the authority to present different cases to the court, and in other instances, what are the functions of the court, which are all listed on the statute of the ICJ. Yeah. So yeah. Another question. Um, um, uh, I can now speak specifically on the ICJ. So when you're talking about the ICJ, how many judges are currently sitting on the International Court of Justice? 15 judges. Yeah, that is correct. There are 15 judges in the ICJ. Yeah, and um, as you might be aware, there's a lot of politics towards the selection of the ICJ judges, but that's a topic for another day. Hopefully, you'll get to discuss it with your public international law lecturers, and um, um, as I said, if you haven't read the ICJ statute, go through it. And also the crowning document, the UN Charter. If you haven't gone through it, make sure you go through it, because as an international law lawyer, these are some of the information you're supposed to have at your fingertips. So I can see that the next facilitator is ready. Maybe Sally, you can confirm the same.
Yes, I am.
Oh, thank you so much. So Salome is one of the Kenya national administrators of the Jessup competition. So those in Kenya will get to see her. She's also the 2021 Kenya national champion of the Jessup competition, which means she represented Kenya in the 2021 Jessup, and she's also an avid lawyer at the moment and is currently in practice. So she'll be guiding you on how to prepare and analyze the compromise, which is the one of the main preparation aspects of the competition. So, Salome Washuka, the floor is yours. Thank you for joining us today.
Okay, thank you so much, Lorraine, and my sincere apologies for joining you late. It's been a bit hectic with traffic and the rains currently going on, so it's been a bit hectic, but I'm glad that I was able to make it. So once again, my apologies. Again, I'd kindly request that you bear with me. I'm unable to switch on my camera, but I promise to take you through a very engaging session. So, Lauren, how many minutes do I have?
Okay, so till 6:20. So um you have 30 minutes.
Perfect. Okay, so I'll try and use the first 20 just to take you through how to analyze a compromise, and then the remainder of the 10 minutes can be used for question and answer session. So thank you, Lauren, for covering the basis of a compromise. And I think in as much as in the Jessup competition, the compromise is the official name that is used. Um, some 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 people also refer it to the statement of facts or the fact sheet. So it takes up so many various names, especially based on different jurisdictions, but it's still the same thing, and it still refers to the statement of agreed facts. So you've talked about Article 36, one of the ICJ statute, and I'd like to see whether anybody is willing to just let us know what entails, what exactly is supposed to be, what makes a compromise a compromise. There are four there are four characteristics that are always associated with a compromise. Is anyone willing to try? You can raise your hand, you can type in the chat box. Any is okay. Anyone willing to share? All right. All right. So just to save on time, ideally, when we're talking about compromise, the four main characteristics of a compromise would involve: one, a compromise has to entail the facts of the case, and that is why sometimes it's also referred to as a statement of agreed facts. Um, it has to entail the issues that are in dispute and the issues that are particularly being brought before the court. Yeah. The other thing is a compromise has to address the jurisdictional basis, and sometimes you'll also find a statement of jurisdiction in some compromise. And lastly, a compromise will entail the reliefs that are being sought by the specific parties. So I think what's very unique about the Jessup compromise is that it's one of the longest, especially in when you compare Jessup to other modes. Yeah, Jessup has one of the longest compromise, then it can be very easy to get lost or confused by the compromise in Jessup. So it's very easy to sometimes also feel a bit. I remember when they first read the compromise, I was a bit intimidated, but with time, once you understand and get to know how to analyze a compromise, you realize that it's very easy. And somewhere down the line, I think I found it to be a bit more interesting. Yeah, so it's it's a just up thing, but you get used to it. So especially now that I understand the question was just released. So yeah, give it 2 weeks. I'm sure you'll find the compromise way more interesting that you're finding it right now, because you'll always discover something new, right? So for those of us who might have not yet interacted with the compromise for next year's competition, um or for anyone who's also read it, I think the first thing that you have to do whenever you read the compromise for the first time is that you have to like just read it once without any interruption, without any thought. Just read it to understand to try and just get an understanding of exactly what it is that you're working with. And ideally, the only thing you should get out of the first read is a description of who the parties are in that particular dispute and the nature of the dispute, which for Jessup is easier because we got the issues surrounding the compromise at the beginning of the year. So it's way easier right now, even when you read the compromise. So just look into the nature of the dispute. This could look like, is it touching on environmental law? Is it touching on the use of force? Is it touching on diplomatic immunity? Just list down as many issues as you can think about, and don't really have to be restricted to what was provided to you, because we all understand the compromise way differently, right? Um, so once you have the first read of the compromise, the next thing will be just to have some sort of a breakdown of the structure as you continue, as you do your subsequent reading, and as you interact more with the compromise. It will be easier and more beneficial if you could identify a jurisdictional clause for one. Um, Understand which treaty, which convention, or which body of law submits this case, right? Right now, we are working with purely the ICJ statute. Great. Um, the other thing will be have your own outline of facts. Okay, so um, when it comes to like the facts, there are those facts that are very ambiguous, and there are those that are very straightforward. So the straightforward facts is those are the ones that you need to identify first, and then the ambiguous facts, that is where you find that most of the issues emanate from. So it's easier to just first of all list down the facts that are pretty straightforward, those that are not in contention, and then you'll find a bit of confusing, if I may use the word confusing. Yeah, that's just it. Use the facts that can be a bit confusing. Just put as an asterisk next to them and just put it down in your notes, because that is where the issues come from. And sometimes you can also use them to frame your arguments and rely on them, because there's no real answer, but there's no yes or no answer on them, and it can be beneficial depending on the nature of the set of facts. Again, but please do not. I've seen this a couple of times. Please do not draw your own conclusions from the ambiguous facts. Just treat them as they are ambiguous. I think the next thing you'd have to I'd advise looking into the materials, yeah, that the court might decide on, or the questions that have been posed to the court, right? And that to have a better understanding of this, it will be easier to read the compromise as as the as the complainant, right? And then as the claimant, and then read the compromise as the respondent, and then read the compromise as a judge. That kind of like puts a lot of things into perspective for you, and it also helps in like, especially if you're able to like separate those two, you separate the claimant and the respondent side you braid, then it kind of helps you gauge how the strength of your arguments even before you get into doing into the competition, and you're able to like identify the weak points in the prosecution, in the claimant side, and the weak points or the weak facts or the weak laws that may not really favor the respondent, and you'd be able to have a sort of, it will give you some sort of an edge compared to other participants in the competition. And lastly, it's also very, very important that you also look at the reliefs that are being requested. Yeah. Um, it just helps put a lot more into perspective, especially if you're looking at the prayers that are being sought. The first thing you have to ask yourself is why, right? Why? What are the consequences of us not getting these prayers? and you'll be and what exactly is going to support you in the set of facts to actually attain these prayers, to convince the court to to grant you your requests. And also, uh, not just the facts, but also the law. Yeah, so whenever you look at a compromise, I wouldn't advise like just reading it as a storyline or as just like a passive novel. If you're able to like get those four facts, sorry, if you're able to read it with the chronology that I just gave you, like look at the jurisdiction, look at the facts, separate the straightforward facts from the ambiguous ones. If you can look into the questions that have been posed, look into the reliefs, and don't just ask yourself, don't just look at them and be like, okay, fine, I understand what this is about, and now I can start doing my research. No, you need to ask yourself why you need these reliefs sought, and what are the consequences of these reliefs. And it will also give you like, it will just jog your mind a bit, and you'll be able to list out like, this is why I feel like as the claimant, we are entitled to these prayers because of this set of facts that happened that we were not really responsible for, and that we were injured in this particular sort of ways. And these are the laws that support us. This is what the law says, and this is why I think the law is on our side as a claimant. Yeah. So it's easier to just look at a compromise that way, and it instead of just reading a compromise and just just diving into the research. Because once you if you just dive into the research, then it becomes like 10 times harder, because you'll keep going back to the compromise and getting frustrated. And it just helps if you understand the facts before you even dive into the research process. Yeah. I think the other thing that you also need to look into are the legal issues surrounding the compromise. So, for instance, I think that the preliminary issues that we're all used to, the jurisdiction, admissibility, um, what's the other? I think I'm forget. It just skipped my mind. But there's another preliminary issue, the locus standi. Yeah. So we all used to those three, especially those of you who are used to mooting as first counsel. Then these are issues that are not really strange to you. But apart from these legal issues that we're used to, look into what else is being framed, or what exactly. And this is why you go now to the issues framed and look at the framing of the issues, extract the legal issue from that framing. And yeah, that it's mostly a very straightforward process, and that is what like informs your research trajectory. Yeah, once you identify the issue, then you're able to dive into your research and be like, okay, I am going to do my best to like look into this. I'm going to look into this particular legal issue, whether it's sovereignty of states, right? Do your research. But again, even as you do your research, I think this is something the next speaker's facilitator is going to speak about. Even as you do your research, it will be way more beneficial for you to also have the mindset of a claimant and respondent. Always argue out every finding that you get, just so that it can prompt you to even dive deeper. Because one thing about Jessup will always challenge you to do a deeper dive into the issues that you thought you already knew about, and that is what makes Jessup, if that makes sense. Yeah. Um. Yeah. So I think that's basically it. And one thing about the facts as well. Sorry, one thing again about the compromise as well is that you'll never get it on the first go. You'd never understand the don't even what I normally advise the students that I train is that don't try and understand the compromise on the first go. It will stick to your head. It will get to a point where you're able to like reference paragraphs from the top of your head, because the compromise is a continuous process. This is not something that you read, try to see what the issues are, and then start drafting your memorials. You always have to come back to your to the compromise, even as you do your research, and as you do your research, and even as you prepare for the oral phase of the competition and even the advanced stages. The compromise never stops to be. It's the first research material that you get whenever you're engaging with the moot, and it will not be wise to just read it once or just a couple of times. I would always advise my students to read the compromise at least every day. Like, I know how hectic it is to do a moot, especially when you're in school, and you still have a lot of research, you still have to do memorials, but going back to the compromise per day helps, because you'll always discover something new every time you read the compromise, or remember something that you'd forgotten in the set of facts that might be relevant to your research and to your and when you're mooting orally, yeah, in the oral phase. So the compromise is something that you'll always have to refer to, and I would advise against doing away with the compromise, especially during the written stage. I know sometimes it can be very hectic, and you want to just be done with the memorials, but sorry, you always have to find time, at least 30 minutes, of your day. Just sit down, read the compromise. And it helps a lot, even when you get to the oral stages, when you get to the oral phase, and when you're mooting, and when you ask questions. Um, as much as you can also get legal questions, you'll always have to rely to tie the law to the facts, and you'll always have to rely on the compromise. So it's even easier to have to be able to quote the compromise whenever you're asked just a random question, and you'd want to move on to your next argument instead of now looking through the fact sheet. It kind of even eats up into your time, right? So yeah. And something else, even as you read the compromise, um I always I always advocate for, one, don't read it as, don't have a fixed mentality when you're going through the compromise, that the jurisdiction issue is only going to be tackled at the beginning of this of the compromise, and perhaps maybe towards the end, when you're told the specific conventions or treaties that you're supposed to rely on when conducting your research. So no, it does not end there. I remember in our year, we the jurisdiction we got to, yeah, it was jurisdiction. So I remember in our year in 2022, the jurisdiction clause was in the attachment. Yeah, so there was a contention on jurisdiction, and if you read the compromise with the fixed mentality that the jurisdiction is only going to be this is something such as the jurisdiction is something that is only addressed at the beginning of the compromise, then it will set you back. And what really helped us is that we used to review the compromise. Me and my teammate will review the compromise on a regular basis, so we're able to highlight that, thankfully, before we submitted the memorials, and we're able to change our arguments in time. So yeah. Something else, please highlight the themes. Uh you can always I'd advise printing the compromise, and then once you print it and then you bind it, I'd advise highlighting the theme or the main issue being covered by a particular paragraph every time you read the compromise. So it helps with jogging your memory, and it also helps you to understand it better. Yeah. So, or if you feel like of course, there are those set of facts that are very, very crucial to certain issues when you're mooting on. You you can always highlight them, you can always underline them, you can always circle them, like just print your compromise and use it to just manipulate it until you understand, you feel like you've understood everything, yeah, in that compromise. I think my Jessup compromise was very I'd written so much, I'd highlighted so many things. By the time we're getting to the international rounds, um there was nowhere else to write on the compromise. So yeah, but it did help, because I did understand the compromise, and even whenever I was mooting, it was very easy for me to refer to certain facts and be able to quote the paragraph and the page from the top of my head. So yeah, I think that's basically it about the compromise. I don't think I've left anything else, and yeah, that's basically it. I will stop there and just open the floor to anyone that may any questions that uh may be there. I'm not sure. I'm not seeing anything on the chat box. So just in case you have a question, please feel free to type in the chat box or just raise your hand and we'll be happy to hear you out.
Okay, you have the floor. If you have any question, kindly speak up or you can type in the chat box. Yes, Chris.
Thank you very much. Can you hear me? Okay, that's fantastic. So, hello, Salome. I hope you're doing great. Thank you so much for this session. My question has to do with relation to the part where you talked about reliefs. So, usually with the Jessup facts, most of the reliefs that are sought for by the parties are declaratory reliefs. So, and I'm just thinking, like, of what importance is it to consider the nature of the relief? Like, I'm yet to see the points that you made on how actually looking at what exactly the reliefs are would impact how you go about in framing your argument or doing your research or something like that. So I don't know if you can just help me take that part again because I really want to understand. Thank you.
Okay. So Grace, I hear you and I get your question and I understand where you're coming from. So the thing is, when you look at the reliefs being sought, or rather, what you'll indicate in your memorials as the prayers that you're seeking from the court, the reliefs are most they're tied to the issues that you're arguing on, and that is where you'll derive the legal issues. And as much as we have the issues that are reflected as well in the reliefs, right? So the reliefs, sorry, will demonstrate, one, the legal issue, and two, once you ask yourself now why this relief is important to the party that you're representing, whether it's the claimant or the respondent, then, and you ask yourself the consequences of these reliefs, or what how they will suffer if they're not granted the prayers that they're seeking, then it is very easy now for you to um go back to the set of facts, look at the facts that justify that relief, look at, and then from there it will be easy to look at the you can now look at the laws that are supporting, look at the laws that are supporting that particular prayer, and then you'll be able to, so now you'll be able to construct your arguments for the memorials and also for the oral phase. I'm not sure that uh that has helped you understand it a bit better.
Yes, indeed, you've clarified my question. Thank you so much. Thank you.
You're welcome. Anyone else with any other question?
Yeah, do you have any questions on working with a compromise or working with a moot question? Yeah, so yeah, then I think that is it. Sally, do you have any final comments?
No, not really. I'm just wishing all the participants all the best in this year's moot. I hope we get to see you at the international rounds, and yeah, all the best. And thank you so much for inviting me for this, Lorraine.
Okay, thank you so much too for joining us today. It looks like every facilitator today is finishing earlier than the allocated time. So our next facilitator is yet to join the session, But yeah, I believe that everyone has received the slides I've shared with you. Yeah. So if you want more details or you also want to review on yourself what um, what you need to do while preparing while preparing with the compromise, because it might look like a minute thing, but so much work needs to be done when you start reading the document before you even start researching it all. So I hope you've gained a lot from Salome. I hope you will go through the slides too, and you'll be able to learn from the same. Any questions, any comments before we proceed? Okay, so I'm assuming there's none. Yeah. Okay, so that is fine. So for those who've interacted with the 2026 question, you will note that the case this year is the case concerning the Guardian Gorge. Guardian Gorge, that's how I'll pronounce it, yeah. There might be different pronunciations depending on the country you come from, but as we discussed yesterday, that really doesn't affect the performance of the competition. The compromise between the state of Alekostia and Restovia, yeah. And one of the questions involves whether Solania can be a party to the case before the court. And that influences the whole dispute. It's part of the first question we are responding to in the moot competition. And at the moment, sadly, because of the Jessup rules, we cannot engage with the topics that relate directly to the competition. In the previous year, we got to discuss deeply on what the sources of international law are and how they apply to the competition, but we cannot do that this year because the third question is actually what are the general sources of what are the general principles of international law, which is a source of law. So we cannot discuss about other areas of law without discussing it. So we are sort of blocked on that. But that doesn't mean that you should not research on the same. Remember, as I said, you're supposed to research on the basics of what you're working on. So for my education, we worked with the public international law textbook of Alina Kaksorosta, and it gave a brief outline on what public international law is, about state responsibility, about all the legalist terms you got to interact with in international law. And I think it was a good book. And if you're new to international law, but also with the direction of your professors or your lecturers, um, I hope take your time to also learn about the sources of international law. As I said, this time it's affected one of the questions of the competition. I look forward to the arguments. I remember also in 2021, General Principles of International Law was sort of part of the research. So for anyone, okay, I'm assuming most of you are doing the competition, so that is a cheat score or something. If you want to go research on it, you can go look at what participants argued in the 2021 competition. I hope I get the spelling correctly. Um, yeah. Uh-huh. Public international law. Yeah. Oh, sorry. Yeah, that is the book I worked with. It's a huge book, but it's a good beginner book for anyone who is first diving into, or if maybe you haven't yet learned it in the course of your education. Remember that the Jessup Moot is not only for law students. Non-law students can participate, obviously with the consent of the universities as they proceed with the competition. Yeah. So let me check if oh yes, she's in. Daniela, hi. I hope you're ready for the session. Huh. So
Hi, Lorraine. Yes.
oh, great. So Daniela is one of my successors. She is the 2025-2026 she's the 2025-2026 student director of the International Law Students Association, and today she'll be discussing on how to prepare for um, the memorial rounds of the competition. As I said, everyone in this session in one or another was a former participant of the Jessup, is a current participant of the Jessup, or in one way or another has been involved in the Jessup. So once again, sit back and continue taking notes and ask questions where you need any clarification. Daniela, thank you so much for joining us today. So I'll mute now and let me share the slides as you start the presentation.
Thank you so much, Lorraine. Thank you so much, Lorraine. Hello, everyone. I'm very happy to meet you all. As Lorraine mentioned, right now I'm a student director, but before this, I did participate 3 times at the Jessup. So thankfully, with our team, we've gathered many tips and tricks to be able to prepare for the written submissions. So if you have any questions, feel free to ask. We'll also have a Q&A part at the end of the presentation. But if you have any questions, please ask them. So this is how you will be preparing for your written submissions. There's a lot of things to take into consideration. For example, the rules of the memorial, the structure of what constitutes a Jessup memorial, what preliminary steps you need to take with your team, an essential part which is the use of IRAC, and some tips and tricks to help you out to prepare for the presentation of the written submissions. So first and foremost, it's very important to take into consideration the rules of the Jessup. Right now, we have some new changes added to the 2026 Jessup rules. So it's very important first for you guys to have knowledge that the deadline is on January 12th at 5 p.m. in Central Time. And the formatting. I feel like one of the most important parts before preparing for the written memorials, I found very easily to first make the structure of each memorial, and that includes the formatting. So you use Microsoft Word, you use letter size, you take everything in Times New Roman size 12 with 1.5 spacing, and please make sure that every time you're making changes into your memorials that you remove any type of comments of track changes that you have to avoid a penalty. I unfortunately, my first year of the Jessup did in fact forget to eliminate one of the comments, and we ended up getting a 5-point penalty. But it was a very good learning lesson that you have to double check everything. Then we make citations throughout footnotes. And a very important part of this is that when you start participating in the Jessup, you're assigned a team number. And this is the team number that you have to put in your memorials, because these memorials are anonymous. And that way, there is no way for the qualification of these memorials to be subjective in any way, shape, or form. Also, I highly recommend having by hand the table of abbreviations that are permitted by the Jessup, because that way you don't make your own abbreviations and have the problem of getting a penalty. However, whenever you use footnotes or you write example, those common abbreviations are completely permitted. And for example, when you cite like international law report or something, those abbreviations are completely accepted to have in the footnotes. So that is not something you need to worry about when you're worrying about the word count on the footnotes as well. And now that we finally move into the structure of a Jessup memorial, the cover page is the first part of the Jessup. That this is where you can actually have images. We usually have a very concise cover page for most teams. So what I would suggest is that you find one of the winning memorials that we have on the Jessup page. And that way you can get more familiar with what the structure is. Because after the cover page, we have the table of contents, and we also have the index of authorities. So every time you cite something, it has to be on the index of authorities, and you must write next to it the pages of the memorial where you have used these authorities. Then we also have the statement of jurisdiction. This has a limited word count as well, so that is very important to take into consideration, as well as the statement of facts and the summary of pleadings. And then you have the pleadings where you actually write your arguments, and then you have the prayer of relief. But the most important part, I would say, is what steps you need to take into account before starting your memorial. So first, this is something that judges say very, very often, that it's read and reread and reread and reread the problem until you have a very whole understanding of what are the key points that are identifying to each issue, how the facts are related to each core issue, and how all of these issues are related as a whole. So that way you can get a better grasp and understanding of the core international law issues, but applying them always to the Jessup problem. Then the most essential part is teamwork. I've gathered that you have to organize with your teams. You have to establish what are the strengths and weaknesses of each person to be able to use them as a whole to improve as a team. And then it's also very preferable that when people divide the issues that they want to discuss, that it's important to remember that the memorial is a team effort. So you always have to make sure that even if you're dividing and conquering on the memorial, you have to write everything as a team. So everything has to be coherent, a same type of redactation style. The grammar has to be similar and everything so that it's coherent, and for the judges it's very easy to read and know that it was made as a team instead of as 4 individual people just writing their own parts, because it's very important then for the oral rounds that you know and understand all of the issues and analysis that you were making in your entire memorial. Then we have the use of basic materials. The basic materials haven't been released yet. They will be released, I believe, at the first week of October. But these are so useful because whenever you're making a preliminary investigation and then you have the publication of the basic materials, it allows you to know if you're going in the right direction. So all of these basic materials, sometimes some of the materials will only be applicable to a certain issue, but it's important for you to read them all, understand them all, and know what is the relevance to the present case. But it's also important to know that the basic materials are just that, they're basic materials. They allow you to give you a guideline of what is the way that your argument should be taking place, but you can go beyond these basic materials. You can research more international law cases from the ICJ, from the ICC, and this way you can maximize your resources. You can make a more profound analysis. You can use doctrine, and this would allow you to have a better comprehension, not only of international law, but also of the issues that you're applying. And sometimes you might think that all of this investigation at one point is tedious, but whenever you're preparing for the oral rounds, you will remember every single thing that you read and how all of this comes together at the end. So this is a very important process to actually take part of and enjoy it. Sometimes it might feel like it's a lot of information, but whenever you get in the zone and start reading all of these materials and you get excited by identifying certain parts and enjoy the process, it might be stressful, but it's very much well worth it at the end. And then review. The most important part is to constantly get together with your team to ensure that there is not only coherent styles, but also sometimes the issues are so related that you have to make sure that an argument that you're making is not going to undermine an argument that your teammate is making, or that one of your teammates is making in another issue. So you have to make sure that everything goes in the same line. And that will also allow you to have a very more whole comprehension of the project, because you will be constantly sharing ideas with your team, and that would allow you to have a better view of what the problem is and how to use these resources. And now on how to write the memorial, we have to have a very good understanding of what the IRAC method is. So IRAC stands for issue, rule, application, and conclusion. And this is a very common structured way to analyze legal cases. And it is one of the best things that you can use for your memorials, because it allows you to have a very organized and detailed way to explain what your view is, what the problem is, what you're applying to justify your position, and what is your analysis, not only of that rule that you're applying, but how do you connect it to the case. But it is important to know that you don't have to use it in everything when you're making your statement of facts. Since that is more narrative facts or storytelling, you don't have to use IRAC in that part. But for example, also when you have issues with multiple solutions, sometimes IRAC may not capture that complexity, but what I found very, very useful is that every time you're making an argument, use your own way of IRAC to make sure that everything's structured in the same way, and it's very easy to read and follow the analysis that you're making. So now we will be explaining each part of IRAC. First, on the issue. If you could change, thank you. The issue stands for what is the question? What is the statement that you're making? So this is the way that you can advocate for your representative. So if you're applicant, avoid using neutral phrases, because you have to present them as submissions that favor your client's case. So for example, I found very easy that when you're starting, it's very good to make questions as issues to identify the problem better. But when you're finally writing your memorial, it has to be more specific and determined. So we have this example. Is the legality of a government determined by democratic legitimacy or by effective control? This is a very good way to identify the problem, but when you're reading it, it doesn't really give you a statement. I don't know if you are in favor of democratic legitimacy or effective control. It doesn't really give you an idea of what is the point that you're trying to make. So you have to be more specific, like in the second example. The respondent submits that the legality of a government is determined by effective control, not democratic legitimacy. And that way you can have a very clear statement of what a person reading this memorial is going to expect of this argument. And the key point is that remember that while yes, it's a Jessup problem and it is an academic competition, these are not academic inquiries, but rather an advocating tool. You're advocating for the person that you're representing, for the state that you're representing in the issue. So phrase it in a way that states very clearly what you're trying to advocate for the representative. And then we go to rule. And this is your source of law. This is what gives backup to your first statement. And for this, it's very important to have a very good knowledge of Article 38.1 of the ICJ statute, because it states what are the sources of law in international law. So first, we will have treaties and conventions, and these are binding rules that are recognized by states. So you could have, for example, the ICJ statute, the UN Charter, and all of these are rules that would allow you to understand better how the ICJ works and how the UN works, and it would give you some backup as to your statement. Then we have customary law, and this is consistent practice accepted as law by states. And in here, whenever you're citing customary law, you would most likely have to write it in a little bit of a longer sequence, because you have to state which states have actually applied this rule of law. Then you have general principles of law that are recognized across all legal system, and then you have the subsidiary forces. And this is when you can use the judicial decisions and the doctrine of highly qualified publicists. So in here, as you can see, you're not limited to only using treaties and conventions. You can also use custom. You can use a book of a highly recognized publicist in international law. You can use the judicial decisions of the ICJ as to have a backup for your issue. And the important part here is that you have to remember always that your issue is your issue, and that is the statement that you're giving. But why is it true? So always remember this question whenever you're finding the rule. Why is your issue true? So in all of this time, you also have to make sure that the treaties that you're using are up to date. You have to also read of the judicial decisions that are important. And I would recommend for also reading the separate and the dissenting opinions, as some of those separate and dissenting opinions have ended up being relevant changes in doctrine. And that way, even if a case states something that might not be in the favor of your issue, you can cite the dissenting opinion and then some doctrine that will give backup as to why might this statement from the ICJ should change due to current circumstances. And then we have the application. And this is the part where this is the most important part, I would say, of IRAC, because this is the very heart of your argument. This is where you give your analysis as to why this rule applies to the issue, why it applies to the specific case that you're giving. And you have to, I would recommend breaking it down into the elements. So you have your rule that states something, breaking down and show why each of these elements is fulfilled and why it applies to the case, to demonstrate how all of these elements are satisfied. And that way you can give a very convincing argument as to why that rule should be taken into account in the present issue that you're giving. So I would recommend in here, this is very important, to always be citing the facts directly from the compromise. Yes, you can mention the facts, but make sure to cite them properly. And the idea here is to construct your narrative to make it favorable and to be convincing that the issue and the statement that you're given is true. So this is the part where I feel like most of your voice comes through, and you have to be convinced, and you have to convince the judges that are reading the memorial that this statement in fact is true. And then we have the conclusion. This is the ending, but it has to be a very strong ending to your issue. You have to deliver it in a firm, clear, and concise way. And the idea here is to tie the issue, the rule, and the application together. This is not the moment to introduce new arguments, and it is not the moment to repeat your analysis, but rather try to summarize in 1 or 2 sentences why what you stated beforehand, why is it that the issue, the rule, and the analysis are true. So this example over here is, accordingly, the respondent submits that the legality of a government must be determined by its effective control, which the respondent undeniably possesses. And that way, it's very convincing, it's very clear, it's concise. So it gives even more conviction to your argument. And afterwards, what I would allow, some of my final recommendations, my do's is that you have to plan ahead. It's a very good idea whenever you get together with your team, but you have to have a plan. For example, by analyzing the strengths and the weaknesses that everybody has in the team, the preferences that they have on some parts of the cases, all of this comes together at the moment of writing the memorial, because you have to be convinced of what you're writing. So if you're writing for something that you're not entirely sure, it's really good for you to match with another member of your team and do a very thorough investigation so that you can be convinced at the moment that you're writing the memorial. Also, it is very necessary to constantly be proofreading. Whenever we're writing, at one moment we get used to our own writing. So even if we wait a few days and then we read our arguments, it might make sense to us, but it's very good to have your teammates, your coach, or your advisor read it to give you feedback. And that way you can understand, okay, maybe I can be more clear in here. I did not give backup or a legal backup to this area. I should add that. And then it's also very important for you to get together with your team to ensure that the memorial has consistency. One of the best tips that I can give you perhaps is to study the past winning memorials. They usually have a very good way of a very good use of IRAC, and from those winning memorials you can learn a lot. You can understand a lot. What if you're not sure of what type of writing to use, what type of grammar to use, these winning memorials are very helpful in that sense. You can get some ideas of what connectors to use, how to avoid repetition, and they give you very good tips. And also, I would recommend adopting the ICJ tone by not only studying the past winning memorials, but also by studying some of the ICJ cases. You can understand what the language is and what the tone is whenever you're writing. So always try to channel that tone to make sure that your memorial is as best as it can be. And then, most importantly, always support each statement that you have with authority. It's very good when you're making analysis and you get excited and you start writing things, but you have to give them back. They cannot just be a statement. You have to give backup to that statement. And more importantly, work as a team. This is the best way to ensure that the memorials is as best as it can be. And then in my don'ts, I would recommend to don't insert your personal opinions or morality. As it's still, this is academic, you're trying to give a convincing argument, and it has to be backed up by the sources of law. So giving your personal opinion might be not what your argument needs to give it the strength or the push that it needs to be convincing. And then most importantly, the facts of the case are the facts of the case. You cannot misstate the facts of the case. You cannot make assumptions of the facts of the case, and you cannot exaggerate the facts. They are what they are. And yes, they might not be working in your favor, but you cannot misstate them, or you cannot avoid them or exaggerate them. And this is what goes to the point by whenever you read something and you go, oh, maybe this is not helpful to my argument, we should just ignore it and not mention it. No, don't do that. It actually gives more strength to your argument if you analyze and you add, you go, okay, yes, so this is true. This goes against my argument. However, on this analysis and this analysis, this is what will give strength to my statement as to why this shouldn't apply, or why, while it might be a weakness, there is another way to interpret it. So never ignore the weaknesses. It usually always works against you if you ignore them, and it gives more strength to your argument if you accept them, analyze them, and try to find a way through. And then don't overcomplicate it. I found that sometimes, especially if English is not your first language, like it is for me, I found with my team that we used to use very, very elaborate words, and that would end up making the reading of the memorial very hard. So try to be simple. It doesn't have to have very decorative words. It just has to be clear, concise, and convincing. And yes, work as a team. Your teammates are your best friends. The ICJ cases are gonna be what you will be talking about for a very long period of time during the research of your memorial. But it becomes a very fun way of learning and becoming friends with your teammates as well. So if you have any questions, that would be the perfect time.
Okay, if you have any question, thank you so much, Daniela. If you have any question, you can ask right now. The use of the term arguendo in memorials. I don't know how to respond to that. Daniela, do you have a response?
I don't know what arguendo. I'm not entirely sure what arguendo is.
Philip, kindly elaborate the question. We are not
Yes,
familiar with the term.
Oh, wait, is that what you use when you go for the sake of the argument or when you go assuming or discussing? Is that a way to express assumption?
He has said yes.
Okay, yes, I would not recommend it. I'm especially if you're referring to the facts of the case, you should not be making any assumptions. The facts are what they are, and even if it would have been useful to make an assumption, do not make it because that would not give your argument the strength you think it will. So I would recommend not making any assumptions, but rather working with what you have and try to find a way to make it make sense for your argument. But please don't make any assumptions. I've made that mistake before, and it doesn't end very well. So yes.
Okay. Any other question? You can raise your hand. You can type in the chat box. What are the guidelines on the use of alternative arguments?
Yes, you can use alternative arguments. This would actually be something that would give a lot of strength to your main argument. And this is a way for you to have a little more richness on doctrine and everything regarding your first issue. However, I would recommend that always make sure that there, at the end of the day, there is a limit of words that you can use when you're making your pleadings. So yes, it's very useful and it could be very enriching for your argument. But if you're over the word limit, that would most likely be the part that I would recommend to extract. You can still find a way to use it and apply it in the oral rounds. Um, but if you're over the word limit, I would recommend to delete that area. But on the most part, yes, they're very useful and they're very convincing as well. And it's also quite interesting whenever you're grading memorials to see someone have such a good use of an alternative argument. So yes, you can use them, but not overuse them.
Okay, so how do I break down my arguments so as to attain a logical flow?
Oh, that's a great question. Okay, so in here is the best way to apply IRAC. So you have the first issue, which is like the first pleading. And usually between that, what you would have, you will see that the issue is presented in a very general way, and you will find that there's several arguments for it. So use subtitles, and then whenever you're making an argument, use the use of IRAC. And to close in that entire issue, have a general conclusion that ties everything together. And that way, when you're reading it, you go, okay, so this is the general issue. This is the part that they are making a statement about. Then you read what the issue, the analysis, the application of the rule of law, and the conclusion. And that way, you can tie everything together. I do believe that using IRAC and using mini IRACs inside of each argument is what will give a better logical flow to your argument because it will be very easy to follow and to understand what your intent is.
Okay, any other question? Okay, so I also agree that was a very elaborate discussion. So yes, any concluding remarks?
No, I would just like to say thank you for being interested in the Jessup. It really is a great experience to learn and to grow not only as a professional but as a person. So take advantage of the opportunity. And yes, Chris.
Okay, thank you, Daniela, for the guidance on how to write the memorial. My question would be, as respondent, sometimes there could be points in contention or laws in contention or several elements, perhaps you might find that the elements of a law are conjunctive or disjunctive in the form of in the form of tests. So perhaps in the case where they are disjunctive or where there are certain points that are not in contention by both parties before the court, would you advise that we still address them all as respondent or just focus on that one bit that is in contention or disprove that one element inside the test or just have to
Um,
disprove everything?
Yes. Okay. So I would actually do recommend that you address them. Usually, the points in contention tend to be there are some that are very specific and others that are quite general. And specifically in treaties and conventions, I would recommend for you to go to the preparatory works because that way you can read what was the intention and what some of the parties were against at the moment of writing that specific rule of law. And that type of analysis would allow you to go into other scholarly debates. So yes, you can address, okay, this is the rule of law. It might, at the moment of interpreting it and the way it has been interpreted, it's this way. It's not applicable to us because the circumstances are different. And right now there's a debate regarding this. And we believe this is the way that it should be applied in this present issue because of the facts of the case. So yes, always address it, and addressing it will actually give you a lot more strength in your argument and a lot more validity in it because the person reading it will understand that you actually know and have a knowledge on why exactly this issue is important to the respondent. So,
Lily, would you like to ask a question? Okay, so I think that is it then. Thank you so much, Daniela. I really appreciate the fact that you agreed to be here today. Hopefully I'll see you next year in Washington, D.C. And to everyone else participating in the competition, you'll get to see her and interact with her during the international rounds of the competition. Yeah. So thank you once again, Daniela, and yeah, see you soon. Yeah. Okay. So a bit of housekeeping. Tomorrow we'll be having the last session, and the topics we'll be discussing how to mainly how to research international law. So a general summary of everything we've been discussing. So what should you take into um, what should you take note of as you're researching international law topics? Next, we'll be having a judge. His name is Jeffrey Robbins. Will be joining us tomorrow. So if you have any questions, especially on the challenges or any anticipated issues or any questions you have in light of voting, whether in the oral rounds or the written rounds, he's judged for a very long time and is familiar with various aspects and various challenges that students might face. So this is an opportunity for you to ask any question you have. So kindly send any questions you have to me and also engage with him tomorrow during the session. Yeah. And then finally, after that, I'll have a concluding activity where I'll be guiding you through the ILSA resources. So ILSA is the body conducting the NGO conducting the Jessup competition, and all the resources are on the ILSA website. So this is just a run through to ensure that everyone is aware of every single resource that ILSA offers to the students. So this includes remote coaches, the whole administration process, your resource as a competitor, and other resources, the history documents from the previous competitions, the videos and all. So see you tomorrow. We'll end the session at that point. I will share the slides that we've used today with you via email. And yeah, thank you for being a good audience. Thank you for being here, and see you tomorrow.